Imagine returning to the family home you've lived in for a decade, only to discover that your spouse has just sold the property to complete strangers.
Oh, wow. Yes.
And they did this without your permission, without even consulting you, and, well, they executed the sale simply because the title deed happens to be registered solely in their name.
It is a shocking thought.
Truly. So the question is, can they legally do that?
Well, it is a scenario that sounds completely counterintuitive to everything we assume about marriage, but under certain legal frameworks, it is entirely possible.
Welcome to this deep dive. Before we unpack the rather harsh realities of this topic, kindly note that the contents of this deep dive are intended for information purposes only and do not constitute legal advice. Always consult an attorney.
Absolutely.
Today, we are conducting a formal legal analysis of a landmark judgment from the South African Supreme Court of Appeal. The case is J.M.M and Another v. Cara, Dorothy, Masureik, and others. That is neutral citation 2026 ZASCA 1.
A very significant ruling.
Yes, it is. Our mission today is to navigate the highly complex intersection where family law collides with property rights. Specifically, we are examining how the accrual system operates when a family home is sold during a contested divorce.
Right. It is an area fraught with misunderstanding.
Exactly. So let us return to that shocking scenario I presented at the start. How does a situation like that actually play out in a court of law?
We can look directly at the factual circumstances of the J.M.M v. Masureik case because it mirrors your opening scenario exactly.
Oh, it does.
It really does. The conflict involved a husband who was the sole registered owner of the matrimonial home, and while divorce proceedings were actively ongoing...
Wait, right in the middle of the divorce?
Right in the middle.
Yeah.
He executed a deed of sale, transferring the property to third-party purchasers.
I see.
So following the transfer at the deeds registry, these new registered owners naturally wanted to take possession of their property.
Which makes sense from their perspective.
Exactly. Which then led them to initiate legal proceedings to evict the wife, who was still residing in the home.
Wait, hold on. So even if she has built a whole life in that house, and they are actively in the middle of a divorce, she has zero legal right to stop him from selling it out from under her.
That is the core of the dispute, yes.
How did her legal team even attempt to fight that eviction? I mean, she must have had some defense.
She did. The wife constructed her defense against the eviction around two central arguments.
Okay.
First, she asserted that her pending accrual claim, which was obviously central to the ongoing divorce, granted her a quasi-proprietary right.
A quasi-proprietary right. So essentially arguing she had some sort of ownership interest.
Precisely. She argued this specific right entitled her to remain in the matrimonial home until the divorce was completely finalized.
Right. And her second argument.
Second, she leaned heavily on the fact that the new purchasers were explicitly aware of the pending contested divorce proceedings. Yes, they knew about it at the very moment they purchased the property.
I have to pause here and just speak to the emotional reality of this situation for the listener, because while we are strictly conducting a legal analysis today, we really cannot ignore how the average person understands the institution of marriage.
Indeed. The emotional aspect is profound.
When you enter a marriage, it is universally viewed as an equal partnership. The family home is regarded as a shared sanctuary.
Yes, a safe haven.
For most people, it feels entirely irrelevant whose name happens to be printed on the title deed at the deeds registry. The inherent assumption is that the marriage itself affords protection over that shared space.
That is the common assumption, yes.
So I have to ask you directly, does the accrual system actually offer any kind of legal shield against eviction in a scenario like this?
Well, this was the precise legal question the Supreme Court of Appeal, or the SCA, was required to adjudicate.
And what did they find?
Their definitive answer, based on the strict interpretation of the Matrimonial Property Act, is no.
No shield at all.
None. The court clarified that spouses who are married out of community of property, subject to the accrual system, do not possess a vested right in their partner's individual assets.
Not at any point.
Not at any point during the marriage.
That terminology is critical for the listener. We need to dissect the mechanics of what the court means by a vested right versus what an accrual claim actually is.
Certainly. A vested right is an established, absolute legal entitlement to a specific thing.
Right.
For example, if you are married in community of property, you have a vested, undivided half share in the joint estate.
So you actually own half the bricks and mortar.
Exactly. However, the accrual system operates entirely differently.
How so?
The court ruled that an accrual claim is merely a contingent financial right.
A contingent financial right.
Yes. It is a potential future claim that simply does not exist in an enforceable state during the marriage.
I see.
Furthermore, it does not magically materialize during a separation or even when divorce proceedings commence.
So just filing for divorce doesn't trigger it.
No, it does not. The legal right to claim a share of the accrual only crystallizes upon the actual legal dissolution of the marriage by a court decree.
So if I am understanding the mechanics of this correctly, an accrual claim is not a claim of physical ownership over the family home.
That is correct.
Is it more accurate to view it as waiting for a final invoice or a balance sheet calculation at the end of a business partnership?
That analogy captures the mechanism perfectly. It is strictly a mathematical calculation of financial value at the termination of the marriage contract.
Right. So during the marriage, the owning spouse can just do what they want.
Yes. During the marriage, the owning spouse retains full, unencumbered capacity to alienate, sell, or dispose of their property.
Just because it is in their name.
Because it is in their name, yes. Because the accrual claim is merely a contingent financial calculation for the future, it does not translate into a personal right of occupation today.
Wow.
It grants the non-owning spouse no immediate authority to freeze the owning spouse's physical assets.
But surely the new buyers are not entirely innocent here. I mean, as you mentioned earlier, they knew they were buying a house in the middle of a messy divorce.
They did.
Why doesn't that knowledge invalidate the sale? I imagine if I am buying a house and I know the seller's spouse is fighting them in court over the assets, I am taking a massive legal risk.
Well, the wife's legal team attempted to leverage exactly that logic. They used a legal mechanism known as the doctrine of notice.
The doctrine of notice, how does that normally work?
Ordinarily, the doctrine of notice applies when a purchaser buys property knowing that a third party holds a prior unregistered right over it.
Like what, for example?
Like a right-of-way or perhaps a long-term lease. In those instances, the purchaser is bound by that prior right because they had notice of it.
Okay, that makes sense. So they bought it knowing there was baggage.
Yes. And so the wife argued that because the purchasers had notice of the contested divorce, their purchase should be subordinate to her right to occupy the home.
Honestly, that sounds like a perfectly reasonable legal strategy to me. Why did the Supreme Court of Appeal reject it?
Because, simply put, you cannot have notice of a right that does not exist in law.
Oh, right. Because we established she didn't have a vested right.
Exactly. The SCA ruled definitively that the doctrine of notice cannot be invoked to assert a right to occupancy when the underlying legal framework, the Matrimonial Property Act, grants no such right.
So, legally speaking, the buyers were purchasing a legally unencumbered title from the sole registered owner.
Yes. The wife held no vested property right. She merely held a contingent future financial claim against her husband's wider estate.
I see.
Therefore, the buyer's knowledge of the divorce was legally irrelevant to the transfer of the property title. The eviction was legally justified.
This really reveals a stark prioritization within the South African legal system. The court is essentially stating that the integrity of the deeds registry and the certainty of property sales are far more important than the unresolved family law disputes occurring inside those properties.
That is the underlying philosophy driving this judgment, yes. The ruling reinforces the bedrock principle of finality in property transactions.
Finality is key.
The entire property market relies on certainty. When an individual purchases a property from the registered owner and the deeds registry confirms that ownership, the purchaser must have absolute confidence in the transaction.
And the banks financing that purchase too, I imagine.
Precisely. If a spouse's hidden contingent accrual claim could suddenly emerge and void a finalized property sale, it would inject catastrophic risk into the real estate market.
It would be chaos.
Financial institutions would refuse to issue home loans if title deeds could be contested based on the emotional or financial state of a seller's marriage.
Yes, I can see how the system would grind to a halt. But if we follow this logic to its natural conclusion, it leads us to a highly critical question for you, the listener.
A very pressing question.
We have established the harsh reality that a spouse cannot legally stop the sale of the family home if they are not the registered owner. So, if the owning spouse decides to liquidate the house, their cars, and their investment portfolios into cash, What prevents them from maliciously squandering or hiding that money before the divorce is finalized and the accrual is calculated?
This is undoubtedly the most significant vulnerability for spouses married subject to the accrual system.
It sounds like a massive loophole.
Well, the law does anticipate this risk, and it provides a remedy, which is discussed extensively in our source material.
Okay, what is the remedy?
The appropriate legal mechanism to prevent asset dissipation is to apply to the High Court for an interdict.
An interdict. But for the listener going through a hostile divorce right now, securing a high court interdict sounds like an intimidating and expensive mountain to climb.
It is not a simple process, no.
How exactly does one go about freezing a spouse's assets?
It is a formidable legal challenge. To secure an interdict against a spouse to prevent them from dealing with their own property, the applicant carries a heavy evidentiary burden.
What do you have to prove?
You cannot approach the court and simply state that your spouse is selling assets or that you are worried they might spend the money.
Which is probably what most people would say.
Yes, but the legal hurdle requires the applicant to provide substantial objective proof of their spouse's explicit intent.
Proof of intent. That seems almost impossible. How do you legally prove what is inside your spouse's head?
It is exceptionally difficult.
I mean, they could easily claim they're selling the house to pay off marital debt or to downsize or, even to fund their own legal fees for the divorce.
You have identified the exact difficulty. You must prove to the court that the spouse is dissipating assets with specific, malicious intention to defeat or undermine your pending financial claim.
So just showing the transactions isn't enough.
It is insufficient to demonstrate that they are executing large financial transactions. You must legally prove their actions are designed specifically to cheat you out of your rightful accrual share.
The bar is exceptionally high.
It is, by design. The law requires substantial evidence of fraud or malice, not merely suspicion, apprehension, or the normal winding down of a joint lifestyle.
Which protects the owner's rights, ultimately.
Exactly. This strict requirement underscores the law's deep reluctance to interfere with an individual's constitutional right to manage and alienate their own property.
Even in a divorce.
Even during a bitter divorce, the owner retains their commercial freedom unless there is demonstrable proof of malicious intent to defraud the contingent accrual claim.
Let us synthesize the findings of this analysis for the listener, because this is a lot to take in.
It is a dense area of law.
Under South African law, specifically guided by the Matrimonial Property Act and affirmed by the Supreme Court of Appeal in J.M.M. and Masureik, an accrual claim is purely a financial entitlement.
Correct.
It is categorically not a property right. The law unequivocally prioritizes the certainty, security, and finality of property transactions over any individual's emotional attachment or assumed partnership rights regarding a family home.
That is the crucial takeaway.
If your name is not on the title deed, your legal protections against the sale of that property are virtually non-existent. And furthermore, protecting the resulting capital from being hidden or squandered requires a severe threshold of legal proof regarding malicious intent.
Yes. As we conclude this legal analysis, I leave you, the listener, with a final, overarching question to ponder.
Please do.
We have established that the strict legal framework of the accrual system treats the family home as nothing more than a liquid asset waiting to be tallied on a future balance sheet.
Right.
Given this harsh reality, does modern property law fundamentally fail to understand the psychological and emotional reality of marriage?
That is a deeply unsettling question, but a necessary one to ask. Thank you for your time and attention to this complex legal matter. We trust this analysis has provided clarity on the intersection of the accrual system and property rights. Good day.